These are the hidden costs of probate in the state of Missouri, what you need to know. Are you worried about the costs or fees associated with probate in Missouri? So today what we're doing is we're breaking down what all those fees and costs and expenses look like so that you can go into this eyes wide open and there won't be any surprises for you. So first of all, probate is the process of going to court when somebody dies. It means it is a process of gathering up their assets, paying any debts and creditors and associated expenses as needed, and distributing the assets to the heirs. Now, associated with that are certain costs and expenses of the administration process. So the first big category of those is court fees and filing costs. So in every probate case in the state of Missouri, you're going to be looking at court fees to file a probate case, no matter what kind of probate case it is. Now, those fees can range a pretty significant amount depending on whether it is a small estate procedure or a full administration, and whether that is supervised or independent. So generally, the court filing fees range anywhere from $70 all the way through $300 to file the case, okay? Depending on the size and complexity of the case. In addition to that, there may also be filing fees for the cost of the inventory. If you're in a full administration, you'll need to inventory the property, and based on the value of that, the court's going to set a fee that they need you to pay as part of the probate administration process. Now, there also might be other associated fees with closing or court-imposed fees, but usually they're not, anything else is usually not too significant as part of the actual court filing costs. The second major category of costs are attorney fees. In Missouri, there are generally three ways that you will see attorney fees billed to you in a probate case. One way is it could be done hourly, right? In certain kinds of estates, your attorney might bill you hourly. They say, we charge X amount of dollars per hour, and the amount of time we work on the case is what we bill to you. This is the traditional historic model of attorney fees. A lot of clients don't like it because they're getting surprise bills all the time. The second way that you may see an attorney charge you fees is through a flat rate. So they may say, coming into this thing, here's what we're going to charge for a small estate case, or here's what we're going to charge for a full administration, right? And the third way is in a full administration in the state of Missouri, there's a statutory percentage that sets the minimum amount that the attorney is allowed to receive as compensation for helping to administer the estate. That fee usually ranges anywhere from 2.5% to 4.5% of the estate. And sometimes what you'll see is a hybrid model where you say, hey, we're going to charge you a flat rate or the higher of the minimum fee, whatever is higher. Because sometimes the percentage doesn't make sense because of the work involved. And it really just depends on the attorney that you're working with and the size of the estate, what you could expect to pay. Can range a whole lot, but that is another category of fees associated with processing a probate case in the state of Missouri. The next category of fees is personal representative fees. So in a full estate administration, the person who is serving as personal representative, sometimes referred to as executor, they are entitled to the same minimum statutory percentage fee that the attorney is. It's calculated the same way, and in Missouri, that gives them a compensation for doing the job of being the representative. Sometimes it's easy, but it can be a lot of work. Another category of expenses, category number 4, might be appraisal and accounting fees. So in larger estates, or where estate and gift taxes or income taxes are an issue, you may need to get appraisals done on real estate or that is part of the estate. There may also need to be appraisals done if there's a dispute over value between the heirs or between the parties to the case. Accounting fees would refer to CPAs or people who are filing tax returns for the estate, because it's something to understand is that the estate is a separate taxable entity from the deceased person, okay? So they may have their personal tax returns, but the estate itself is a taxable entity that generates income, generates expenses, and needs to file a tax return if those income and expenses exceed a certain threshold. Now, in many cases, we don't see the need for this. The income to the estate it just isn't any, or it's not significant enough to trigger that amount. But in the cases where it often becomes necessary to hire an accountant to help do the tax return for the estate. Other things that you might see in probate are miscellaneous costs. These would be things like publication fees. So in most cases, you will need to publish notice in the newspaper of the probate of the estate. It will either be a publication for the appointment of the personal representative, or publication that an heirship hearing is going to occur and we're determining who the heirs of the estate are. All those sorts of things require publication in the newspaper. And in the state of Missouri, the cost of that can vary wildly. We see in St. Louis County, St. Louis City, St. Charles County, fees for publication typically range anywhere from $60 to about $100. If you go out into more rural counties, ironically, the cost of publication tends to increase pretty dramatically. We just had a case last week where the publication in a rural county is going to be over $800 for the publication of the case. And I think this just happens to be because they probably don't do as many of them, and so the newspaper space is probably small and more valuable. I don't know what the reasoning is, but publication in rural counties is usually a lot more expensive than it is in bigger cities for whatever reason. In addition to publication, you may see other administrative costs for things like postage or shipping or delivering things to heirs and beneficiaries, either from the law firm or elsewhere. And one other cost that you will probably need to incur in Missouri is the cost of purchasing a surety bond. So a surety bond is designed to protect the estate against fraud or mismanagement. So let's say you as the representative come into possession of the estate's money and you decide, I'm going to steal this and take it to Mexico and I'm not going to give any to my brother and sister. What brother and sister are allowed to do is then file a claim against the bond company saying, hey, your bonded person stole the money. We'd like to be made whole. So the bond company, what they're doing when they agree to issue the bond is to pay that money, assuming it can be proven up. And then the bond company goes back after the representative saying, hey, you stole the money. We paid it. You owe us back. So it's not like insurance in that way. You got to be you do not want to mess around with it. But surety bonds are often a required prerequisite to being appointed representative, to being issued the small estate affidavit by the court, or the small estate certificate clerk by the court. And it is in many cases a requirement. The important thing to understand about bonding is that it is based on things like your credit history, your criminal background, your bankruptcy history. So it's a good idea to try and get that sort of thing in order before trying to go through probate if you can. But it really varies quite a bit. Sometimes the bond can be waived. Okay. So now let's talk a little bit about tips for reducing these costs. The biggest thing you can do to reduce all of these probate costs is to not go to probate at all, right? And if you have transfer on deaths on your bank accounts, if you have a trust that holds your property, if you have beneficiary designations on your 401ks and IRAs, none of that property goes through probate in most cases. And so any of that property is not going to be exposed to any of these costs. If you do have to go to probate, it can be very helpful to have a will. And what that will does is there will be a few important features of that will that make things easier. They will waive the surety bonding requirement, because you can waive that requirement in a will. You can say my representative does not have to buy a surety bond. And that's one of the few circumstances where you can definitely waive a bond in almost all cases. Saves usually several $100s. We've seen bonds over $1,000, $1,500, depending on the size of the estate. And that's an annual fee, right? So it's nice to be able to get rid of that. The other thing you can avoid is you can set whether or not the representative is going to take a fee. They're still entitled to a minimum if they want to take it, but you can give some guidance. You can set a different fee if it's reasonable. And you can also find other ways of minimizing the expense associated with having somebody appointed. So having a will can definitely help get people appointed more quickly, more easily, minimize disputes, and it is a great way to help minimize the cost of probate. But at the end of the day, the best way to minimize the cost of probate is to not go to probate at all. So understanding the costs involved in probate can make this process less stressful, but it can also help you better understand how to get around it and what we're trying to avoid when you hear so many attorneys and friends and family talking about how important it is to have a trust or have your beneficiaries set on your bank accounts and properties. So if you have any questions, and if you're in the state of Missouri and you have any questions about probate, feel free to reach out in the links below in the description, and we're here to help you every step of the way. Don't forget to like and subscribe to this video, and we'll see you next time.